always late. Down!
To start off the video, the general rule under the English common law is that there is no general duty to disclose information that is known to one contracting party but not to the other during pre-contractual negotiations leading up to a contract. This has been established fairly early on by the case of Fletcher and Krell, whereby the court held that a woman was not obligated to reveal the fact that she had already been previously married when adopting the role of governess, despite the prerequisite for her to do so at the time.
You can't be a governess. You were once married.
I don't have to tell you that.
Yes, you do. And what is this?
Another example of this can be seen in the case of Keats and the Earl of Cadogan, whereby the court held that a landlord was under no obligation to describe the condition of a property to a tenant prior to any lease agreement. Other than that, mere silence, no matter how morally wrong, cannot amount to an action of deceit under non-disclosure as established by the case of Bradford Third Equitable Benefit Building Society and Borders. The reason for this refusal of disclosure is best illustrated by Professor Fright's examples of oil companies or conglomerates carrying out extensive and expensive geological surveys in order to determine which land houses valuable natural resources such as gas and oil that would be valuable to them. Once they have identified said lands, they can then proceed to purchase it through a broker from whoever it is that owns said land without having to, number one, review the purpose of the survey, number two, review the results of the survey, or number three, to even disclose their identity when purchasing it at market price. Therefore, if said seller decides to claim against the agreement, the English courts will uphold this agreement, as under the English position, there is no duty to disclose such information to the seller. The reasons behind this is pretty simple, as the information that is held by the buyer is financially valuable, and to have him disclose the information to the seller without just compensation would be to, number one, unjustly deprive the buyer of his valuable information. Number two, disincentivize future buyers from spending the money to carry out the research needed to obtain such information in the future. And number three, this would unjustly enrich the seller who, without conducting any research on his own, would now therefore know that his land is much more valuable than he initially thought and would therefore raise the prices in order to gain more profit. Another reason why that there is no general duty to disclose is because of the fact that during a contractual agreement between buyer and seller, each party are usually at arm's length and at odds with each other. This means that each party would like to get the best bargain that they can possibly get on their end, and it would therefore be pretty unreasonable to have them share valuable information that will affect the prices that they can get between the both of them. Next, if the courts were to impose a duty to disclose all information, this would lead to them having a floodgates of cases, as they will now have to decide what, when, how, and in which situation the general duty would apply and when. Although the section 1, 2, and 3 of the Misrepresentation Act 1967 uses the term misrepresentations made, this covers active misrepresentations and does not affect non-disclosure of information. Therefore, the Act does not impose any liability for non-disclosure of information that has not existed before, and it does not affect or vary any current liabilities or defenses due to non-disclosure of certain information.
There are many important exceptions to the rule that there is no liability for non-disclosure. In this, a person is in general bound to disclose only facts which he knew or which he would have known if he had not willfully shut his eyes to them. A person may not, however, be under a duty to disclose facts which, though not known to him, were known to his agent, if that knowledge had been acquired within the scope of the agent's authority, and if it was the agent's duty to communicate it to the principal. He may also be under a duty to disclose facts which he ought to have known if there is a special relationship between the parties within Hadley, Byrne and Heller. The first exception is where a party actively or intentionally hides or conceals a fact. It has been said that a person must disclose latent defects in the subject matter of the contract which are known to him. But cases which may appear to support this view are best explained on the ground of active misrepresentation by words or by conduct. In Schneider and Heath, the sellers knew there were issues with the boat. They kept the boat afloat so that the buyers could not see the faults. When the buyers found out later, the court held that the buyers could rescind the contract. The next exception is fiduciary relationship. There are cases in which the person is under a fiduciary duty which he can discharge merely by making full disclosure. This is the position between principal and agent, partners, and between company and its promoters. A company promoter owes no such common law duty to the person who subscribed for shares in the company on the face of a prospectus listing, particularly issued by him, but he does not owe them an extensive statutory duty of disclosure. In Armstrong and Jackson, there was a broker who did not disclose to the clients that the shares being sold were the broker's own shares and not those of a third parties. Another exception is where a representation has been made and before the conclusion of the contract, the statement turns out to be false. There is a duty on the person who has made the statement to disclose this change. In the case of Witt and O'Flanagan, the owner of a medical practice put a correct figure as to the value of the medical practice. However, the value then went down and the practice became worthless because of the owner's illness in the intervening period which stopped him to practice. The contract was set aside on the grounds that the vendor ought to have communicated this change of circumstances to the purchasers, but there will probably be no need to disclose minor variations in the income of the practice. And there are obvious limitations on the scope of any duty of disclosure which may arise from a statement, such as one as to a person's financial position, which can influence a series of transactions extending perhaps over many years. A time must come when the representation loses its force and the representee begins to rely rather on its own judgment. Next exception is contracts of the utmost good faith. There is a duty to disclose material facts in contracts uberrimi fide in which one party is in a particularly strong position and the other in a particularly weak one to know the material facts. In the contracts of insurance, it is up to the insured to positively disclose any fact that might make the underwriter decide which premium to follow. If he doesn't, it is not really a contract, but the assured need not disclose facts which the insurer himself knows or ought to know, facts which diminish the risk, facts which both parties have equal means of knowing. General topics of speculations and the facts the disclosure of which is waived by the insurer. Prudent insurer would take into account in deciding whether or what premium its disclosure would not necessarily have an effect on the decision whether to take the risk, or at what premium or on what conditions he would take the risk. A fact may be material even though its disclosure would not necessarily have an effect on the decision whether to take the risk or what premium. This duty of disclosure gives a generous measure of protection to insurers. In Woolcott and Son Alliance, the person taking out the insurance did not disclose that he was an ex-convict for robbery. The insurance company did not have to pay because of this failed disclosure. The final exception is a person is guilty of misrepresentation though all the facts stated by him are true. If his statement is misleading as a whole because it does not refer to other facts affecting the weight of those stated. In the case of North Spaden Brick and Tile Co. and Butler, a purchaser of land asked the vendor's solicitor whether the land was subject to restrictive covenants. The solicitor then replied that he was not aware of any, but failed to add that this was because he had not troubled to read the relevant documents. The solicitor's reply, though literally true, amounted to a misrepresentation entitling the purchaser to rescind. The duty of disclosure in cases like this is narrower than that which exists in contracts uberrimi fide. The maker of a statement which is literally true but on the whole misleading is required to disclose only such facts as affect the weight of those stated. He need not disclose further facts merely because they might be reasonably regarded by representatives as material.
In Malaysian law, free consent is needed in order for an agreement to become a contract. The requirement and definition of free consent can be found in Section 10, Section 13 and 14 under Contracts Act 1950. Section 10 states that an agreement is a contract only if it is made by the free consent of the parties. Next, Section 13 states that two or more persons are said to consent when they agree upon the same thing in the same sense. Under Section 14, subsection C and D, consent is said to be free when it is not caused by inter alia, fraud or misrepresentation. Fraud and misrepresentation are defined in Section 17 and 18 respectively. Fraud happens when the maker of statement has intention to deceive the other party. Misrepresentation is when has no intention to deceive the other. The common law for fraudulent misrepresentation and fraud under Section 17 of Contracts Act 1950 are similar. Common law, negligent and innocent misrepresentation and misrepresentation under Section 18 Contracts Act 1950 are similar. Under the explanation to Section 17, the silence of a party from the disclosure of certain factual information does not render the act as an act of fraud. Illustrations A and B to Section 17 also shows how the general rule regarding non-disclosure operates. In the case of Lau Hitia and Hagyu Engineering Sdn Bhd and another, claimant bought a loader on hire purchase terms from defendant. During negotiations, defendant's dealer did not inform claimant on the machine's year of manufacture or it had been involved in an accident previously. Claimant also did not ask about these matters. Later, claimant wanted to rescind the contract by claiming that defendant did not disclose the material facts. Relying on the explanation to Section 17, the court held that the defendant has no duty to inform claimant on the two matters above. The general rule is caveat emptor, which is let the buyer beware. The buyer is responsible to inspect the goods to be sold or not before any sale and purchase agreement. Buyer has a choice on whether to exercise this means of protection against defective goods or not. However, a duty to disclose material facts might exist in certain cases of contracts. Section 17 of Contracts Act 1950 was also applied in the sales of goods contract. Furthermore, in relation to directors' contracts of service or services, there was no requirement in the Companies Act 1965 that disclosure to members is necessary of its terms or that members' approval is mandatory before a service contract is offered to a director. Next, the issue on the duty to disclose material facts can be seen in the case of Pua Land and another and Banda Eco Setia Sdn Bhd. In this case, the claimant, who are husband and wife, purchased a double-story semi-detached bungalow from defendant, which is the developer. Claimants found that there were cracks and damage to the bungalow caused by the foundation of the property, which contained black soil with palm tree trunks and waste. Claimants sued defendant on the failure to disclose the fact that foundation was not suitable for construction, unsuitable soil materials, and the safety of the property. The court held that non-disclosure of facts does not give rise to a cause of action in misrepresentation because there's no duty on the defendants to disclose facts. In the case of Yunko Enterprise Sdn Bhd and Tang Tiu Hing, the second defendant has signed a guarantee for the repayment of all outstanding sums due and owed to the claimant for the goods supplied to the first defendant. The claimant sued the defendants for the sum of the goods sold and supplied to the first defendant. The second defendant said that the claimant did not tell her that she was signing a guarantee and the claimant did not give her a copy of the signed guarantee. Second defendant states that the guarantee should be void. The second defendant also relied on the Section 96 of Contracts Act 1950, which permits the court to decide whether the guarantee is a contract of utmost good faith. Second defendant wanted to rely on the fact that the claimant did not disclose the risk she was undertaking as a guarantor, but the provision in Section 96 will not help the second defendant as the guarantee is not a contract of utmost good faith. In the case of Heng Cheng Swee and Bangkok Bank Ltd, which is decided by the highest court in Malaysia, there is no duty in the part of the claimant to disclose all material facts known to plaintiff. The case above shows that Malaysia does not impose a duty to disclose material facts known to the contracting party but not to the other party during the course of negotiations leading to the formation of the contract.
The explanation to Section 17 and Section 18b in the Contracts Act 1950 provide exceptions to the general rule that mere silence does not amount to fraud or misrepresentation. The exceptions cover the situation in which the law treats non-disclosure as fraud or misrepresentation. The first exception is that where a fiduciary relationship exists. The explanation to Section 17 specifically refuses to treat mere silence as to facts likely to affect the willingness of a person to enter into a contract as fraud. However, the circumstances of the case are such that duty to impose upon the person keeping silence the duty to speak, then his failure to make disclosure amounts to fraud. A fiduciary relationship is one of trust and confidence. It involves one party acting for the benefit of another. Lowther and Lord Lowther, the plaintiff, handed over a picture to the agent for sale. The agent knew of the picture's true worth yet brought it for a considerably lower price. The plaintiff subsequently discovered the picture's true worth and sued to rescind the contract. It was held that the defendant was in a fiduciary relationship with the plaintiff and accordingly assumed an obligation to disclose all material facts. Accordingly, the contract could be rescinded and recover the painting was allowed. Next is that a contract of uber reme fide is a contract of utmost good faith. Similarly to fiduciary relationship, the parties are required to make known all the material facts influencing the contract. Contracts uber reme fide usually arise when one party has knowledge which the other does not have access to. The law imposes on the first party that duty to make a full disclosure of all material facts to the other party. Failure to do so will render the contract voidable. Contracts which are commonly considered to be of such a nature include contracts of insurance and family agreements. This is seen in the case of Toh Kim Lian and Asia Insurance Co. Limited. In insurance law, utmost good faith has two important aspects: misrepresentation and non-disclosure. Both the insurers and the assured have to observe utmost good faith towards each other. However, in practice, the problems that arise in relation thereto involve the assured's duty only. This is because the special facts upon the contingent chance is to be computed lie most commonly within the knowledge of the assured. Hence, it is the assured who is required to disclose material facts which are known to him. When applying for insurance, the person or entity must disclose all material facts so that the insurer can properly assess the risk involved with the offering of the insurance. Since the insurer cannot have access to all information relating to the insured and their situation which could affect the risk involved, it is necessary for this disclosure so that both parties are entering into the contract on an equal ground. The Malaysian Insurance Act 1996 has abandoned the long-established common law test of materiality. Section 150 thereof has opted to follow the footsteps of the Australian Insurance Contract Act 1984. It says that the exception silent is as good as speech is shown in the illustration of C, Section 17 of Contracts Act 1950. The illustration is shown as:
If you do not deny it, I shall assume the horse is sound.
It provides another exception that silence does not amount to fraud. Furthermore, where silence regarding an undisclosed fact, half-truths or partial disclosure gives a false impression, such situation may amount to fraud when the facts are not disclosed. In such situations, the law imposes upon the representer the positive duty to rectify the wrong impression by making full disclosure. It is the breach of duty to make full disclosure that gives rise to fraud. Next, where a representation is true when made but becomes untrue subsequently, the representer is under a duty to disclose. In course of negotiations, parties make all sorts of representations of fact to each other. In law, the validity of such representations may continue unless denied or corrected or until the negotiations are concluded. In other words, the law may treat representations as continuing in their effects until the parties conclude their contract. It is because law treats representations as having such continuing effect that imposes upon a representer who discovers or becomes aware that a statement which was true at that time, it has subsequently become untrue. Finally, where there is concealed fraud, a party will not be allowed to conceal a fraud and then attempt to profit from it at the expense of another.
The law imposing a duty to disclose information before a contract has been entered into has since undergone several reformations, and several more suggestions have been made in order to reform this area of the law. This is because in McHugh's journal, A Vendor's Duty to Disclosure, this modern practice of when you can disclose information and when one party can't disclose or doesn't need to disclose information, this modern practice is quite time consuming and inconvenient, and therefore there were several suggested ways of reforming this area of the law made by both journalists and the judiciary. So one of the possible reforms lies in the case of Nottingham Patent Brick and Tile Co. and Butler, where a more open approach was taken by Lord Justice Millett. To summarize the case, an owner of a plot of land divided the land into several subplots, and the defendant bought one of these plots of land. So there was actually a condition in these conveyances that stated that the land sold would be accepted irrevocably, even if there were any defects in the property. So the defendant bought one of these plots of land and sold it to the claimant. So in the deed between the defendant and the claimant, there was actually no mention of that condition. However, it was stated during the negotiations. But the claimant actually asked the defendant's solicitor to further explain on this condition. However, the solicitor actually claimed that he had no such knowledge of this condition. Therefore, in this case, Lord Justice Millett held that the equitable rule, where a full and frank disclosure of material facts to which are important in a contract should be required, and it shouldn't be ousted by a condition in the contract which kind of is designed to relieve the vendor of his duty to disclose such material facts before the contract is formed. So though Millett agreed with the modern practices of practicing prudence before entering into a contract on part of the innocent party, he also said that he won't allow the purchaser's imprudence to relieve the vendor of his obligation to candor or to be honest. Furthermore, in employment contracts, case laws are seen to be moving slowly towards recognizing an implied duty to disclose information before and during a contract. So there is a traditional duty of cooperation and loyalty on part of the servant or the employee. However, in this suggestion for reformation, this duty should be extended to a duty by the master or the employer to disclose information to the employee. So the courts have impliedly imposed such duties upon the employer, mostly for the sake of employees' health and safety. So though this approach has not been expressly incorporated into the English and Malaysian law, however, this implied rule has developed greatly, especially in the area of employment law. So therefore, it's seen here that the duty of disclosure before the time of contracting can be extended when concerning important matters such as employees' health and their well-being. The duty to disclose information has also played a key role in business practices. So while there is no legal obligation to do so, information is disclosed, it's by practice to one party by the other for the greater good of their business. So a simple example would be where an owner of goods hears on the radio that there will be a traffic jam on one of the roads on which the carrier of the goods is about to travel. So the owner could, and often does in business practices, opt to disclose this information to the carrier in order to avoid any delay in the delivery. So if the owner doesn't disclose this information, it wouldn't bring any benefit to the owner or the carrier, since there would be damages payable due to the delay in delivery, and this really doesn't help the situation in terms of their business. So since costs like this can be easily avoided by a mere phone call, the criterion of wealth maximization implies a duty of disclosure of such information. Thus, it is said in business practices that a duty of disclosure should be imposed when such an act would eventually lead to the successful completion of a contract. This is especially true when one party would only need to make little to no effort in safeguarding the other party's interests. Under this circumstance, perhaps the informal implied duty should be enforced by the UK and Malaysian courts of law for a more efficient completion of a contract.
Thanks for watching.